The next case on the calendar is A.H. versus Henry, the matter of the adoption of E.I.C. How much time would you like for rebuttal?
5 minutes, Your Honor.
All right, whenever you're ready.
Thank you, Your Honors. May it please the Court. My name is Nick Shanine, and together with my partner Carol Shanine, we represent A.H., who is the mother of the child, in this case about the Florida Adoption Act. It is a case about adhering to the statutes as promulgated by the Florida legislature. It is a case about Florida's Constitution's right of privacy in the act of parenting, and it is a case in part about the absolute right to dismiss an action pre-judgment pursuant to Rule 1.420. This is not a case.
The final judgment of adoption has been entered, right? And that's what we're looking at.
That is correct. It has been entered. Before it was entered was when both only 2 months after the petition was...
This couple had adopted a child before.
That is correct, Your Honor.
Okay, but that's not an issue in this case, is it?
And in fact, that is a perfect example of the proper application of the GP versus DP decision, that if there is no challenge to an adoption until a judgment has already been entered by a lower court, you can't come back afterwards and challenge it on the basis that that judgment was voidable. It's too late, and it should be too late. That is done. If you challenge it before...
Is it your position that adoptions by gay couples is not authorized under the act and therefore are void?
No, absolutely not. There's no...
You would be hard pressed to make that position given the fact that you utilized the adoption procedure before on another child, right?
Well, first of all, I want to make it clear. In no way or circumstance is the argument being issued by the appellant that same-sex adoptions is any different from different sex adoptions, that they are absolutely identical and should be identical, that the law of the land as issued by both...
Your position is same-sex adoptions are fine provided the procedure is followed and the law is complied with. Okay.
That's exactly right. If you follow the procedure as set up by the Florida legislature and as ruled upon by the courts, including this court and DMT, then everyone has the right to adopt.
In this particular case, the consent was given, and then it was attempted to be withdrawn a little bit later, right?
It wasn't attempted to be withdrawn. It was withdrawn.
Well, what did the trial court say?
Okay. That she revoked her consent only 2 months after they had filed this joint petition, which was...
After you offer and give your consent, how long after the consent is given do you have to... Is there a time limit?
There is. It's up till the judgment is entered.
Pardon?
It is up, according to Rule 1.420, a plaintiff or a petitioner is the master of their complaint. And you can withdraw your consent up until the day of the judgment. Now, where there is some confusion, perhaps...
Janine, that's not what the consent that was signed by your client said, correct?
The consent as drafted was clearly the consent that's encapsulated within the statute regarding when a birth mother is giving up the rights of all of their rights to the child. And there's 3 different places within the statute which make it clear that that is what we're talking about. And in fact, every single case by any Florida court ever reviewing the consent provisions discusses it in exactly those terms. The consent is not the consent of a mom who isn't giving up her rights at all, and in fact, that's what the most recent case...
Well, Mr. Shanine, the consent, with all due respect, is a little inconsistent with what you're saying there. In the first paragraph of the consent, it says, I consent and agree to the second parent adoption. okay? So
That
your
is true.
client's agreeing to that. Now you're coming before the court saying that second parent adoption was not permitted under Florida law, correct?
That is correct.
Okay, and the same consent that was signed in an earlier adoption, correct?
That is also true, Your Honor.
Okay. In the second paragraph, it says that your client is, that the rights will vest with the appellee, and that they will be irrevocable parental rights as a legal parent of the child, correct?
That was exactly what she said at the time she filed the consent, but before any judgment was entered upon
She
that.
agreed to that at the time she signed the consent.
She did.
And then in the third paragraph, it says, this consent to adoption is valid upon execution. However, it is subject to revocation, a revocation period of 3 business days.
Which is the consent provision that's provided by statute for mothers who are giving up their rights. And that's exactly what the most recent decision, and I give credit to opposing counsel who filed it before we had completed our shepherdization of the most recent cases, the IB versus EES decision from the 4th DCA, which goes through exactly this, even where not only in that case did they consent to it before the judgment, they consented to it at the time of the hearing before the judge, and the judge goes, you know, I can't do that. It's
But
not.
you're also saying, you're saying when the parent gives up their parental rights, but yet in paragraph 2 of the consent, it then says, in no way is it going to modify my parental rights, and that's your client, correct?
Correct.
So your client's not giving up her parental rights.
That's what when she filed that in June of 2014, that's exactly what she said. But she didn't have that ability under Florida law to do it. If a judge had granted it, then it becomes res judicata.
Let me ask you this.
Sure thing, Your Honor.
Regardless of whether or not we have a consent, and regardless of whether or not this is a 2 women or a heterosexual couple, regardless of whether there's a consent to adopt, does Florida law allow for second parent adoptions when it is not a step parent, when the couple is not married?
It does not, Your Honor. The statute is very clear that 63.087 sets out right at the very top, prerequisite for adoption. A petition for adoption may not be filed until the date the court enters the judgment terminating parental rights pending adoption, and then it gives the 3 exceptions. And these 3 exceptions apply whether it's same sex, whether it's different sex, whether you've got consent, whether everybody agrees. It doesn't matter. You can only do this in 3 cases. Adoptions of relatives, the biologically corrected, and that's where the DMT, HMT type of situation comes in. In situations of adult adoptions, if you're over 18, we don't worry about any of this. You can get adopted. Or adoptions of stepchildren. So if you've got a marriage in the situation, then absolutely you can do it. And all of these were options for this couple at the time that this judgment was entered, but none of them were done.
And is this initially, did the couple go to Miami? They went to Miami with the first child,
They did.
correct? Because they believed they would get a favorable ruling there.
That is correct, Your Honor.
And obviously, they're not going to appeal an unlawful ruling.
That is correct, Your Honor.
And did they go then back to Miami for the second child?
Even though they were living in Brevard County, they filed the case in a county where none of them resided before a judge that would not have had jurisdiction over them but for their agreement to file there. And that is why ultimately, once the revocation of consent came in and then the motion, hey, you need to either dismiss this case or at the very least boot it to Brevard, the judge was like, well, I'm going to boot it to Brevard, because this whole thing of second parent adoptions, it was a fiction that existed and needed to exist, frankly, when the Obergefell case had not become the law of the land, when Brenner v. Scott had not become the law of Florida. At the end of 2014, Northern District of Florida entered an order that made Florida absolutely acknowledge same-sex marriages, and that went into effect January 6, 2015. The courthouses here in Central Florida were open for business that morning, marrying couples. This was all before the judgment was, well before, years before, the judgment was entered in this case. Later that year, Obergefell came down from the Florida Supreme Court, making it clear, all 50 states, all territories, this is the law. Everyone has the same rights, same sex, different sex, Any sex, doesn't matter. You have the right to get married.
When was the, I don't have it in front, when was the petition filed and when was the breakup?
Sure.
When did they split?
The petition was filed on June 17th, 2014. The breakup happened only a month after. And then on 8/21, so 2 months after the petition was filed, that's when the mother had gotten an attorney to file a revocation of consent in Miami-Dade to make it clear that, okay, I agree, but before the court had acted on it at all, before any action had happened in the court, she had filed her revocation.
Is that a requirement in the case law for the court to act upon a consent?
It is a requirement if we're going to have a court do something that is not otherwise allowed by the law. And here's what I mean by that.
So what's the reason then for the 3 days?
Well, because we need to have the ability for couples to rely upon the special consent that's given when a birth mother is going to give up their child for adoption. The adoption proceedings won't work, and the framework of the state will grind to a halt for adoptions. And I have to segue on that, because adoptions are not a common law creation. Adoptions are specifically a legislative creation, and because of that, we have to follow the guideline that the state provides, and every state is a little different on this. So it's hard to look at other states comparatively and make sense of the framework because they are different. But where I'm going with that, Your Honor, is because we have our statutory framework, we must follow it, and the state wants adoptions to work in instances where we have a birth mother who is going to sign this consent to give up her child for adoption so that other people can rely on it and adopt those children without the fear of it being revoked. This is a fundamentally different instance.
And it gives them 3 days to change their mind.
It provides that period, and it makes it abundantly clear in multiple different circumstances and that's actually brought out in the brand-new 4th District DCA case, where they run through all of the provisions of Chapter 83, where the act defines the adoption as the act of creating the legal relationship between a parent and child where it did not exist. Another section stating that the effect of a judgment of adoption is to create the relationship between the adopted person and the petitioner that would have existed if the adopted person were a blood descendant. These are all provisions that are made to allow for the consent the way it's supposed to be according to the Florida legislature. The consent that was crafted here is clever. And it worked for the first adoption.
It worked entirely the first time.
It did, and no one is trying to render that asunder. And that is, the thing is that the Florida Constitution provides that a birth mother has these rights to decide which non-parents are going to interact with her. If she is going to keep her child, which non-parents are going to interact and work with her to help raise that child. It's her right to decide that. And the court decisions have been clear, starting well back with the Florida Supreme Court through the DMT decision here, that these inchoate rights that exist for the biological founders of the children have that right to make those parenting decisions. And it doesn't matter whether their biology comes by way of the sperm, by way of the egg, by way of being a birth mother. All of them are considered valid for being a relative pursuant to this court's decision that was affirmed by the Florida Supreme Court in DMT. So what's critical is, as Judge Berger was pointing out, is to review this statute. What does it allow? And the second parent adoption simply is not a listed exception. And if someone's going to try to raise it afterwards, they're out of luck. But if you're going to raise it before that adoption occurs, that's exactly when you're supposed to raise it. That's exactly when she did. And these judges struggled with it. One judge said, I'm not sure. The next judge said, we're right, that you can't do this adoption. And then a successor judge came and a motion for reconsideration was filed, and that judge switched course.
And that law applies regardless of whether you are a heterosexual unmarried couple or a gay unmarried couple.
Same sex, different sex, no sex does not matter. The statute is the statute. It must be followed. It needs to be followed.
Your position is that the consent can be withdrawn anytime up to entry of the final judgment.
And an analogy would be if a bride-to-be walks into the courthouse and happily signs a marriage certificate, I intend to get married. And you have a 3-day period before you can get married.
I think you may have stated it, but the consent was given on a certain date, and then how long after the consent was given was there an effort to withdraw it?
Only 2 months.
I'm sorry?
Only 2 months. That 6/17 was when the petition for adoption was filed, 8/21 was when a revocation of consent was withdrawn, and then later the attorney decided, you know what? I've consulted with a civil attorney who says you can get rid of anything, even if the other party hates that you're dismissing it, you can do it pursuant to Civil Rule 1.420. And so by November of that year, over a year before this judgment was entered, is when a official verified notice of voluntary dismissal was filed. So 2 months until a revocation of consent is filed, and a few more months.
They both filed the petition, so she could dismiss herself from that petition, but she certainly couldn't dismiss.
She
the
could
other
not
party.
dismiss the other party, but the problem is the other party doesn't have standing without her. That if it had been the other way, if the former partner, who was not a biological parent, was not a birth mother, was not a relative, if that individual had revoked her consent to it, she can do that, but the other person would still have standing, although she was the birth mother, so she wouldn't need to have standing. But
Okay, if they had been married, how would that have changed the?
it would have changed everything, because if they had been married, then, well, first of all, Privet might have kicked in to say if you're married at the time of conception, then there's a presumed legitimacy to the child. But independent of Privet, if they were married,
Let me
then
ask you this, what if the birth mother was married prior,
Sure.
had a baby, her husband passes away, she remarries,
sure.
and they go through a step-parent adoption. Before the adoption is complete, they split up.
Right.
And they divorce. Would the adoption still have to take place if the mother no longer wanted
Correct.
her next husband to adopt that child?
That is a critical distinction here, and the answer to that is no. You could consent to it at the time you filed the consent all day. Without a question, you can consent to something, but then if those circumstances change before the judgment of adoption is entered, and the birth mother is the one that is objecting, the step-parent who would have been the adoptive parent, but now there's this divorce, and it doesn't make any sense to force this biological mother to allow for the new husband who has potentially wronged her to still have an involvement in the rearing of a child that he is not biologically related to, he's not otherwise related to. Absolutely, that it would be just as wrong for the court to enforce that adoption against that biological mother's wishes before judgment as it would be in this instance.
Is there an equal protection problem here?
There is not an equal protection problem because, as we've been discussing, different sex couples, same-sex couples, everybody can and must be treated the same. And that, because there is not any difference in the way this statute is now to be applied to individuals, there is not an equal protection problem. And with that, I see that my time is in rebuttal, and I would like to reserve it.
Okay.
Thank you, Your Honors.
All right, you may proceed.
May it please the court, Christina Alonso on behalf of the appellee DC, and I'm joined by trial counsel Nora Rotella and Patricia Hernandez, as well as DC herself. Appellant argues that the trial court erred in finding, first, that her adoption consent was valid
Do you
and binding.
concede that the statute does not allow for second-parent adoptions second-parent adoptions?
Absolutely not.
Where in the statute does it provide for unmarried couples to adopt without the birth mother terminating her parental rights? Show me in the statute where it says that.
Section 63.042 subsection 2 provides that an unmarried adult may adopt. Therefore, DC could adopt under the statute.
But under that
in-
circumstance, the birth mother would have to terminate her parental rights. In a situation where a birth mother is not terminating their parental rights, but is maintaining custody and parental rights of the child, does the statute provide for an adoption by a person who is not a step-parent?
The statute does not prohibit it. If we look at that 63.042, it doesn't provide that the unmarried adult would only qualify if it's a step-parent. Beyond that, in the DPP decision...
What would be the purpose of having a step-parent adoption? If it doesn't make a difference, then why would the legislature put in, they don't put superfluous language in.
Well, because they proceed differently. An adoption by an unmarried adult proceeds differently from a step-parent adoption. So
Right.
where there's a
What
step-parent...
is required by an unmarried adult adopting is that the birth mother terminate her parental rights. That's the difference.
I would say that under the circumstances of this case, it would be an unconstitutional application.
And why did
because
the couple go to Miami to facilitate an adoption there when that was not in their jurisdiction?
that was where their attorney was located. That was where the first adoption took
That's where
place,
they
and
would
so
get a
that's where they
favorable-
proceeded.
that's where they would get a favorable
Without question,
decision.
they thought that they would get, I'm sure, a more favorable ruling there that was within constitutional bounds. If we look at the DPP decision, this court in footnote 2 states that the adoption was consistent with the intent of the legislature. The intent of the legislature is to provide children with two parents. A birth parent has a privacy interest, has an autonomous right, a familial autonomous right to determine how to raise that child. That right under the Constitution has to include the right to share that parental right with her same-sex partner, which is...
The DPP case hinged upon the issue of judicial estoppel. You would agree?
I would agree, Your Honor.
Okay, we don't have judicial estoppel here,
Correct, Your Honor.
Okay, we have potentially equitable estoppel. Why? But I note that neither party argued equitable estoppel in this case. Why didn't you argue equitable estoppel?
What I argued was waiver, which is consistent with equitable estoppel, that waiver being consistent with the consent. She waived her constitutional rights in the consent. It's consistent with a Forbes decision, which recognizes that a parent has a constitutional right to waive, recognizes the parent's constitutional right to privacy in rearing the child can be waived. There, the court stated that there is a presumption against the waiver of constitutional rights, and for a waiver to be effective, it must be clearly established that there was an intentional abandonment of a known right. And in that case, they found...
In this consent, do you have a clear waiver of the birth mother's constitutional rights?
Without question, Your Honor, the consent states, I hereby voluntarily, knowingly, and intelligently waive any and all constitutional rights existing under the Constitution of the State of Florida and or the Constitution of the United States and or statutory rights existing under state or federal statute and or rules or procedures existing under state or federal law to challenge the enforceability of a final judgment of adoption entered herein by which the parental rights of DC shall thereupon stand upon the same plane as my own as to the child. It was a clear waiver of that right in that consent. Beyond that, I completely disagree with appellant's interpretation of section 63.082 that governs consents.
Let me ask you this. The hypothetical that I gave Mr. Shanina with regard to heterosexual couple and the husband dies, and I mean, are you saying in that situation when the wife consents to the step-parent adopting the child and they divorce and they're unmarried at the time before the adoption, that she can't withdraw that consent?
2 points on that. First, because step-parent adoptions procedurally are different, there wouldn't have been a consent. A consent is not necessary in a step-parent adoption. So if it would have proceeded as a step-parent adoption, there would be no consent. And so, yes, the parent would be able, prior to the entry of the final judgment, say, I am now withdrawing my consent, because there is no waiver in that situation. So I would say
So
that's
the
different.
3-day rule doesn't apply in that scenario.
If there's no consent, then the 3-day rule does not apply. So that brings me back
They would have,
to,
she would have had to have consented to the step-parent adoption. As the mother of this child, she would have had to have consented to that adoption. So you're saying that in that situation, the 3-day period to revoke would not apply?
not necessarily if it didn't comply with the statute. So let me explain why the consent here does comply with the statute. Because appellant keeps arguing that the statute required the consent to include a termination of parental rights. And that's simply not correct. And that is what they argued in their reply brief. There was a typo. They referenced subsection 3E of the statute. There is no subsection 3E. The subsection is 4E. And that is the subsection of the consent statute that sets out that form language of what needs to be included in the consent. And there is a reference to a termination of parental rights. But if the court looks just below that form quoted language, it states, this statement of rights is not required for the adoption of a child older than 6 months of age. A consent form for the adoption of a child older than 6 months of age at the time of execution of consent must contain a statement outlining the revocation of rights provided in subsection C. If we then look at subsection 4C, it provides, if the minor to be adopted is older than 6 months at the time of execution of consent, consent is valid on execution. However, it is subject to a revocation period of 3 business days. That language is in the consent. And so the consent that was signed in this case completely was consistent with section 63.082. Appellant also ignored section 63.2325, which governs the invalidation of a consent and states that a consent can only be invalidated where there's a failure of fundamental fairness in the administration of due process, or the failure constitutes or contributes to fraud or duress in obtaining a consent to adoption or affidavit of non-paternity.
Ms. Alonso, was it Judge Holcomb? He found that there was no evidence of fraud or duress and found no basis for the revocation of the consent, correct?
Correct, Your Honor.
Was there any other judge, I know this case was handled, given different times by, I think it was 3 different judges. Did any judge find that there was a valid reason to revoke the consent outside of the 3 days?
No, Your Honor. The first order is at record page 606, and that is the order that Your Honor is referencing, and that order was entered following an evidentiary hearing. Following that, appellate moved for reconsideration. Reconsideration was denied, and so the second judge also, and that order is at record page 678, found that the consent was also valid and freely and voluntarily given. As well, the third judge in the final judgment of adoption also found that the consent was valid and was freely and voluntarily given. And so 3 different judges considered the issue and found that, yes, appellant was bound by the consent. I would like to mention the case that was recently released by the 4th District, the IB versus CES case that appellant addressed. With regards to that case, I would first point out that it distinguishes the DPP case on the basis that the DPP case was consistent with legislative intent in terms of allowing the 2-parent adoptions. It says petitioners in DPP were in a committed relationship at the time of the adoption, and the child was born into a 2-parent home where the parents were in a familial relationship with each other and the child. That's precisely what we have here. So even under the 4th District's decision of IB, this would be an appropriate adoption consistent with legislative intent. Beyond that, I would argue that the decision was wrongly decided to the extent that it found that the father could not also be a petitioner to the adoption. Why? First, even the 4th DC acknowledges that the statute is unambiguous in terms of providing that the judgment of adoption relieves the birth parents of the adopted persons, except a birth parent who is a petitioner. So that's the language. Except a birth parent who is a petitioner, the judgment of adoption has the effect of terminating parental rights. Now, the 4th District says, well, a petitioner there has to be someone who is seeking to adopt, that does not already have established parental rights. But then I would say that would render that language superfluous. Because if the judgment of adoption confers parental rights to the adopting parent, why would the legislature then need to say that that very judgment of adoption does not sever the rights of the birth parent, unless the birth parent already had parental rights as a petitioner? So in that regard, I would say that they're straying, number one, from the unambiguous language of the statute, and number two, not reading the statute consistent with legislative intent. Beyond that, it's an unconstitutional application of that statute, because a parent does have a right to privacy and parental autonomy, and that would need to include the right to share her parental rights with her same-sex partner.
Also her right to not share her parental rights when the couple breaks up.
Definitely, Your Honor. But of course, in this case, there's a consent that's binding. And the effect of appellant's argument would be to call into question consents that the parties and the court rely upon. The whole purpose of...
Well, in my hypothetical, the parent gave consent too, and the couple broke up.
Well, I would...
And what if they were not? Okay, so say this. Say they weren't married, but they were just in cohabitating in a committed relationship, but had not remarried, and they were beginning this adoption, and the couple breaks up. You're saying that she would not be able to withdraw her consent to that adoption when this is say it's a, how old is the child in this case?
Well, at the time, she was just older than 6 months. She's now 4 years old.
Okay, so, you have a 6-month-old child that, so really, there's some bonding there, but you've got a 6-month-old child, and the parent's now saying, I don't want this person to adopt my child anymore. You're saying that the court would make her, and it was lawful to make her, the mother, allow this person that she's no longer in a relationship with for whatever reason, say it's say it's a case of domestic violence, and so she doesn't want to be with this person anymore because there's an issue of domestic violence, and so she can't withdraw her consent to let this man be the step-parent of the 6-month-old child?
Yes, Your Honor, that's precisely what I would say, because that's what the Florida statutes call for. If there is a valid consent that is signed, that is consistent with the statutes, the legislature has already set out the circumstances under which that valid consent might be invalidated. And that is not one of those circumstances. And there's an additional consideration that distinguishes this case from a typical step-parent.
Is there a case out there that says that allows for, with that precise factual scenario, that would allow for an adoption in such a case?
All the cases that have addressed the consent statute have been in cases where there was a termination of parental rights. So this is the first time that the court is considering that factual scenario.
Because when you're dealing with an adult adoption outside of marriage, that's a non-parent, it's a situation where the mother has to terminate her parental rights.
Well, but if our legislature is willing to say that a parent only has 3 days to withdraw consent when their parental rights are going to be completely eliminated, then certainly it's appropriate after 3 days to say that they have waived the right to challenge that, where they're sharing the
So
rights
that
and not
is-
completely
But
terminating.
it's understandable what the intent is in that particular situation, because you want permanency for these children that are going to be adopted by two parents, or or a single parent, if we're allowing single parent adoptions pursuant to the statute, and that the birth mother isn't going to come back after that and say, no, you can't have. I want to raise my child, and you as a family can't have them. It would halt adoptions in this state. So there's certainly a valid reason for that, and when you're dealing with the termination of parental rights, to have that 3-day window. It gives the birth parent, an opportunity to change their mind, and then you have to have a cutoff period.
And we certainly also have that here, because there needs to be permanency and stability for children of same-sex parents who were not able to marry, and we can't ignore that.
Well,
That's
this couple was able to marry. This couple went to Miami because they felt like they could get a favorable ruling, and there were couples all over this country that were traveling to Massachusetts who allowed same-sex marriages in 2004, and to the state of New York that allowed same-sex marriages in 2011. So just as they traveled to Miami to get a favorable ruling in an adoption case, they certainly could have traveled to the state of Massachusetts or the state of New York to marry if their intent was to get married.
under the state of Florida law, they were unable to get married in
Absolutely,
Florida.
I agree.
Also, under Florida statutes, Florida would not give any recognition to a marriage entered into another state. So either way, at the time when the couple made the decision to conceive these two children, because the decision was made at the same time, choose a sperm donor, have two children. Everything went fine with the first adoption, now we go to the second. At the time that the consent was signed in May, at the time of 2014, at the time that the petition was filed in June of 2014, and even at the time that they attempted to withdraw the consent 3 months later in August, the couple still was not able to marry in Florida, and Florida still would not have recognized any out-of-state marriage or marriage in any other recognition.
In August of 2014, it would have.
I'm sorry?
In August of 2014, the state would have recognized it pursuant to the federal opinion.
Well, the federal opinion provided that it would not take effect until January of the following year. So the earliest that a marriage would have been recognized would have been in January of 2015. But in any event, it would have foreclosed the parties in this case from marrying. And so it would be an unconstitutional application in this case to say that there was a need to terminate parental rights when it would have been superfluous to do that when the intent was to share parental rights. It's within their constitutional right to have done that.
Alonzo, what was, I know your time is getting ready to come to a close, but what was the indicia that your client and the birth mother intended to marry, even though legally they could not marry prior to it being legalized in the state of Florida?
They had a commitment ceremony.
Okay. Was there anything else?
They lived together. They jointly chose the sperm donor. They had their first child. That adoption went through, appellant consented to that. Then they proceeded to have the second child. There were home studies done. Appellant chose the agency that conducted the home study. They jointly filed the petition and submitted it with the consent. So every step of the way, the intent was for both parents to have parental rights.
And were both adoptions done through the same agency?
Yes,
And were both adoptions, did they use the same consent? The same form of consent?
I believe so.
Okay. All right. Thank you.
After the birth of the child, how long did the two remain together?
Let's see, the child was born in September of 2013, and the petition was filed in May of 2014, and the
Just
appellant had her
approxi-
change of heart in August of
Just
2015.
approximately, how old was the child when, when the couple separated?
About 11 months old?
11 months?
Yes.
Ms. Alonzo, one other question. Was there a name change that took place as well?
Yes, Your Honor. Appellant changed her last name to appellee's last name so that both of them would have the same last name and so that both children would have the same last name as well.
Okay, did that require an affirmative name change for the minors, or no? Did their name?
No, that was done before they were born.
Okay.
Before both children were born, that occurred.
So all four parties, I'm referring to the children as separate parties as well, they all had the same last name?
Yes, they all did at that point in time.
Okay, thank you, you're out of time.
Thank you, Your Honor. I would rest on my brief for the remainder of the arguments and ask that the court affirm.
All right, she had about a minute and a half more, so I'll give you an extra minute.
Basically, this case hinges
I'll
on the
take the
validity of the consent. If it was proper for your client to withdraw, then as far as you're concerned, that's it. That's an automatic one for you. If the consent was improperly withdrawn and was valid, as the trial judges have indicated it was, then what's your position if the consent was valid?
All right. To start with, yes.
I mean, the question is, the case hinges on the validity of the consent, whether it was properly withdrawn.
It hinges on two things, Your Honor. It contingents on whether she could revoke a
Right.
consent. And to be clear, Your Honor, this is not a case of equitable estoppel. And the reason why is because the thing that she had been asked to sign and she signed was well before a final judgment was entered and would be in derogation of a Florida statute and the Constitution of the state of Florida. That if you are going to allow for a procedure that cannot exist, you can't waive that and have that binding stick even if it's objected to before the judgment is entered.
The bottom line is, if we say, and I'm not telling
Sure.
you how we're going to rule, but just for example, if we
Sure.
say that consent was valid and she waited too long to try and withdraw it,
Okay. If that's what this court says.
you lose. The final judgment of adoption stands.
And I still do not believe we lose because
So the issue is the validity of the consent and your client's right to withdraw.
my client's right to withdraw and what the statute says, that Judge Berger was asking very pointed questions about, does a second parent adoption exist under Florida law? And a review of the statute says it doesn't. And there's a reason why people went to Miami to do this procedure, because the judges there would grant it, or so they hoped, and so it happened on some occasions. Because that's not what the statute says, and the Fourth District Court of Appeal got it right. They couldn't have been clearer. They went through each of these arguments that we have here, and they say, when you look at the whole statute, it is abundantly clear that this is not the individual. A person can't have their cake and eat it too. You can't give up your rights and keep them. You can't petition for adoption if you're already a parent and you intend to stay a parent, and that's what makes this consent different. This consent attempted to simultaneously say, I waive my rights and I keep my rights, and you can't do that. And the Florida statute makes it clear you can't do that. The Fourth DCA makes it clear you can't do that.
That's exactly what you did in the first adoption. Right?
That is what they did, and this court's decision that judgments need to be final is a correct decision, and no one here questions it. DP, GDP all agree that once you have entered that judgment, but that's the other thing about this consent, Your Honor, is the consent talks about her waiver to challenge enforceability of a final judgment of adoption. If she comes to the court before there is a final judgment of adoption and says, in exactly the scenarios that Judge Berger was explaining, that it would be amazing for a court to say, you, the birth mother, the mother of the child, the person whom the United States Supreme Court has held as a natural parent, has a fundamental liberty interest in the care, custody, and management of your children. You have no say anymore over whether this person who you do not wish to co-parent with, who is now leaving you, who may have domestically abused you. I'm not saying that happened in this case, but in the hypothetical that was given by the court.
In this particular case, the couple was together for 11 months, raising the child together.
Well, they were together for only 1 month as a happy couple for purposes of whether they wanted to stay together until they broke up. They stayed together in part to help to raise the child until
They
that
parent- they
devolved too.
parented the child together. Each is an equal partner in the parenting process, right?
Well, you
For
have.
that period of time, though.
For that period of time, but the differences are manifest, and this court has made clear the exceptions exist for natural parents, it doesn't matter which direction of biology, and that was available to this couple too, had they wished to do so. The DMT solution, they could have employed that. The Go to Massachusetts solution, at any
If
point,
they'd have gone to another state to marry, Florida wouldn't have recognized
but they would have at least have had that marriage in place, and then on January 6, 2015, long before this adoption got granted, they would have, and people knew months in advance that this was coming. The clerks of court were preparing, some clerks of court were electing not to actually marry individuals within their courthouse, although the local jurisdictions did. That could have been the case. That was not the case here. Because the revocation came only 2 months after filing the petition, well before the final judgment, and because the final judgment talked only about whether she would challenge it after it was entered, means that if she says, no, this must end now, before it gets entered, you can't force the mother to go through with that when she's the birth mother and intends to hold on to the child. Thank you, Your Honors. I appreciate your attention here, and on behalf of the mother, ask the court to reverse.
Well argued on both sides.
Very well argued on both sides.